Hi, this is Attorney Stephen Rue, and today we're going to talk about major holiday visitation and summer visitation. Pardon my casual attire today. It is the holiday season as I'm recording this now, but I thought it was a good time to actually have this tutorial discussion about what parties should do in litigation with regard to major holiday visitation and summer visitation. First of all, it's very important that unless you have an excellent relationship with the other parent of the child or children, that you get your major holiday, summer visitation, and other relevant visitation to be specified in writing and made in order of the court. So please consider doing that immediately. Now, when doing so, it's important that for major holidays, often you have flexibility in working with the other side as to what the major holiday visitation is. In other words, what is included and not included in it. Here in Louisiana, of course, we have Mardi Gras, so you add that into the mix potentially if you celebrate Mardi Gras. And you can decide with the other parent whether or not the major holiday should be alternating or whether or not a parent should have each major holiday, or how you plan on doing that with the various family rituals and schedules of your particular family unit, the grandparents and other people that you have ceremonies and certain events that you do on particular holidays. So there are basic plans that can be used, but again, they can be made more flexible according to the specific facts of how your child or children live with your extended family members and yourself. Quite often they're alternating, but they don't necessarily have to be. Some families like to celebrate Christmas on Christmas Eve versus Christmas Day. They have events for New Year's Eve versus New Year's Day, Thanksgiving, etc. You need to include what specific major holidays will be included in your holiday schedule. Write those things out. Also, you must or should consider each parent's birthday as well as the child's birthday and how to handle the physical custody of the child during Father's Day, Mother's Day, and each parent's birthday. That certainly can be worked out. It's important to understand that generally when you work on a consent judgment, that is a written judgment that is presented to the court to be filed, that you have these specifically worked out as to, on an odd year, for example, 2019 is an odd year versus 2018, which is an even year. Who will get that child or children on that particular holiday, birthday, etc. So that all can be worked out, and I recommend should be worked out in advance. Because what happens if you don't do that, for example, the week before Christmas or the week before Thanksgiving or any other major event, if you don't have that worked out, then it's going to be very hard to enforce on the day that you actually want the visitation for that major holiday or major event. It should be in writing. If you can have an agreement, that's fine. Again, I recommend that it is in writing, but the best thing to do in every occasion is to have a consent judgment order, so that if law enforcement unfortunately would have to be involved, or someone looks at contempt on the back end of the case after the event has occurred and the visitation is not provided, that someone may go in and ask for contempt for the other parent's failure to abide by the consent judgment. Also, it's important to look at what kind of summer visitation or physical custody will the various parents have, so that there's sufficient time for each parent to take the child on an extended vacation if they wish to. Usually you see that a minimum of 2 weeks. It could be longer. Sometimes it's consecutive weeks, sometimes it's non-consecutive weeks. Again, you have flexibility in determining what that is. However, it's better to get that in advance. Quite often what we see is that each parent gets a certain amount of weeks during the summer for their holiday vacation with the minor child. And usually what you see in most orders is that you provide written notice to the other parent 30 days in advance in order to secure that vacation time. I strongly recommend you talk to an attorney that is representing you with regard to how to make that happen. Also, Louisiana, quite often parents are subscribing to Our Family Wizard by order of the court or just by them voluntarily agreeing to do so. And that is a great way to communicate with the other side. Hopefully you have a good rapport relationship to be able to communicate as a good co-parent with the other parent. But if not, that even gives you more reason why everything should be in writing, either through Our Family Wizard, by text, email, etc. It's best to have evidence that there was written communication given proper notice. If in fact in the consent order you can do so and have summer visitation by a 30-day written notice. The worst thing to do, and that's why I'm doing this video during this particular holiday season, is that the worst thing is not having your ducks in a row, to have things in writing, to have things planned out, because quite frankly, courts get jammed with all kinds of motions being filed at the last moment that so-and-so is not being able to go on a cruise, so-and-so is not being able to go to Disney World or on vacation, or is not releasing the child for their major holiday visitation or summer visitation, and there's no written document or consent judgment to allow enforcement. And quite frankly, a lot of courts leave a few days earlier and are frankly unavailable to handle an emergency hearing or make an emergency decision on the eve of a vacation time or a major holiday. So get these things in writing in advance. If you want more information, you certainly can read one of my books, Louisiana Child Custody, Visitation, and Support, or of course the Louisiana Divorce Handbook, both of which that I have written. If you have any further questions, simply give us a call. I'm Attorney Stephen Rue at 504-529-5000 or 985-871-0008. You can also reach us at stephenrue.com. Have a good day.